Good evening, everyone, and welcome to the first in our new webinar series of family law seminars. We're going on from today until the end of June, covering a range of topics. Tonight's going to be me. I'm Siân Smith, and I'm going to be giving you an update on financial remedies case law. So we're going to look at a number of cases within the last 12 months, looking at some mostly High Court decisions, but some decisions from the circuit bench as well. Obviously, those decisions, we have to bear in mind the Lord Chief Justice's practice direction. They're not authoritative judgments, but they are sometimes excellent examples of how cases are being dealt with at that level, and also can provide some really helpful summaries of the applicable law. Right, so let's get started with some interim applications. The first case I want to talk about is a case of Mr. Justice Mostyn, Xanthopoulos and Rakshina, Legal Services Payments Orders. So starting right at the beginning, really. A couple of cases on this theme tonight. The preparation for this hearing, he says, can only be described as shocking. We'll see, as I say, a couple of decisions along these lines, but we have a plethora of sins, skeleton arguments, too long and filed late, I think, filed as late as on the morning of the hearing in one case. And the bundle, no authorities gave 350 pages, but went up to 1,878 pages. And what Mr. Justice Mostyn made of that was really to make a point, and it's made in another case we're going to come across this evening, that the deliberate flouting of orders is a form of forensic cheating. And should be treated as such. So it's the High Court bench taking the view that there's an advantage to be gained in not complying with orders and filing long documents in particular. And we should clearly understand that non-compliance may be regarded as professional misconduct. So we do need to be careful and be better at dealing with these points. So the case itself was the husband's application for a legal services payment order. The wife was also seeking release for an undertaking concerning £11 million that she had in a bank account. Again, another theme for tonight, I think you'll find more and more. The costs in this case were eye-watering, some other words certainly as well, but described by Mr. Justice Mostyn as being apocalyptic and self-harming. So they stood around for 5.4 million. And this was before the first appointment at the hearing for the payments order. And there was a note really in the judgment saying someone needs to do something about this, but it's not really can't be done within the case law because our warnings are going unheeded. So we'll have to see what happens, but I think we can expect more cases where judges are taking issue with the cost being incurred in these very big money cases already, although this one wasn't a particularly huge case in terms of what was available on the papers. So the husband's application came, he already had an order for funding, and he had greatly overspent on that order. I think he had something overspent already by about 250,000, and he was seeking another large sum to get him through to the first appointment, hundreds of thousands of pounds to get from where he was to there, drafting first appointment documents and questionnaire, which the court thought was outrageous and not proportionate. In the event, he couldn't proceed as his solicitors had come off the record, and therefore he didn't have a really case to put in respect to the costs that was relevant to what was actually going to be incurred, but in any event, the judge gave consideration to various elements of his claim, given what was his clear view that he was unlikely to succeed on any of it. And I've put in there reference to the decision of Mr. Justice Cobb in Re Z as well, which is referred to in the judgment, where it really makes the point that if you get a order providing for funding up to a certain point in the proceedings, in this case first appointment, and the solicitors, counsel and client go well over that, they shouldn't be expecting to come back to the court to get more out of the paying party, because the judge has already assessed what is appropriate and what the budget effectively is, and the expectation of the court is that that budget will be worked to and not just flouted. So that's the sense of this judgment, and also the judgment of Mr. Justice Cobb. Another interesting general proposition is this: the husband was, of course, seeking the amount that he'd gone over, so the amount he owed his solicitors, as I say, about $250,000, I think. And the court said this, that the order would only be made in respect of outstanding costs to current solicitors, where without payment those current solicitors would likely cease to act. So in order to preserve representation, in this case, where the husband's solicitors had come off the record, payment of their outstanding costs had no relevance to the question of whether he could continue to access representation. And so they were effectively a creditor of his in the usual way. So that is an important point to know as well. So moving on to another interim application, maintenance pending suit, another decision of Mr. Justice Mostyn in Collody, Fuchs and Fuchs. This is an MPS application in the kind of case that I would say we're not dealing with every day. Net assets of the husband were at 1.245 billion. It was an ultra high net worth case. The wife's application is relevant probably only to us as a means of the eye-opening sums that she was claiming, total of about 4.34 million a year, taking into account all the overheads. The case really turned on an interpretation of a post-nuptial agreement, but this was, of course, the interim position. Significant costs incurred already. What is helpful in this case, and the reason for looking at it when it is a case that's so far out of the reach of most people, is the summary of the law in relation to maintenance pending suit at paragraphs 40 to 46. It does have a particular emphasis on dealing with a big money case, with an emphasis on looking at things in more detail, because there can be absolutely huge sums of money involved. And also to note that in that case, there was no interim budget, and that wasn't regarded as being necessary in the particular facts of the case. I just go from there into the final decision in the same case, focusing in on the issues of child maintenance. The rest of the judgment deals mainly with the interpretation of a prenuptial agreement, which is mainly fact specific and not something I think we need to consider in any detail. Again, for our purposes, a detailed summary of the law on child maintenance and the principles to be applied, extremely helpful in dealing with cases where you are coming to, particularly cases where you're coming to the court because the paying party earns over the statutory maximum at the CMS of 156,000. And it brings together some of the case law on this point that have been developing in the High Court on slightly separate tracks. And what Mr. Justice Mostyn says is that his previous suggestions that the child support formula should apply to gross annual incomes between 156 and 650,000 pounds is a pragmatic guideline that is intended to apply forcefully in cases being decided under the Matrimonial Causes Act, where the child support is a subsidiary claim of a wider financial remedy claim. And so that effectively steps up a starting point, and then the wife's budget and reasonable needs will be considered within the usual set of criteria in her spousal claim. And he makes the point that it'd be rare that in a financial remedy claim you're only looking at child maintenance, although of course sometimes that will happen, and if it's a variation case, or perhaps there's other reasons that the wife is not seeking any other provision. But he goes on to say that in cases where that is the case, of course, is just looking at child maintenance, then the case law under Schedule 1 is going to be relevant. And then you are looking at the following principles, which I have distilled, but bear reading in the detail of that judgment, because it's an extremely helpful description. But the highlights are these. The welfare of the child has to be a constant influence. The award can extend beyond the direct expenses of the children to meet the expenses of the mother's household, but not expenses that are directly personal to her and have no reference to the children. Now that is an interesting point. He gives some examples, which are these. So one couldn't justify a nightclub subscription for as part of a child maintenance order. I think that would be self-evident, but it would be possible to justify the purchase of a car, and it would be possible, he says, to justify the purchase of designer clothes, which have some reference to the children on that basis. The task is to look at the reasonable level of the household expenses, judged by not only the father's current standard of living, on the basis the application is made by the mother, but the standard of living of the family before separation, when they were all together. The level should be set such that the mother is not burdened by unnecessary financial anxiety, and there should be a broad brush approach to the budget. The concept of a carer's allowance, which has really fallen away these days in any event, but you will recall maybe the times when the costs of a nanny or some other care provider would be put forward as providing some guidance on the type of award that could be made under this head. And Mr. Justice Mostyn makes clear that that is an approach that quite properly should be confined to the history books, and the approach is to look at the level of the household expenditure as being the relevant one. Moving on, I'm going to have a look at some cases that deal with general principles. So just alighting really on some interesting points as they've been decided, and some excellent summaries of the law that we can use to put our own cases before the court, distill into skeleton arguments, or just use ourselves. So this is a judgment of Mr. Justice Peel, HD and WB, and deals with a number of issues. One of interest in the computation stage is assessing liquidity of a minority shareholding, and there's an excellent summary in terms of the applicable law, really coming down to this two-stage process that the judge identifies, which is a finding that the likelihood of the third party assisting the spouse in accessing the funds, and that finding will depend on the facts of the case, and you have to take everything into account, including any previous assistance. And if you get to that finding, then the court has the evidential platform to make an order which might amount to judicious encouragement to the third party. So an order that the husband, let's say, makes a lump sum payment, which will give some encouragement to that third party. In this case, however, the minority shareholding that the husband held in his family business was not liquid, and it was not a resource that he was reasonably able to take into account. There wasn't a market for the sale of minority shareholding. It would be realised if the entire business was sold, and that wasn't on the cards. So having gone through that process, that was the conclusion reached, very briefly described by me in that case. Other aspects of the case related to the validity of premarital agreement. And again, we've got an excellent summary of the applicable law within the judgment. The argument of the husband was that the postnatal prenuptial, I'm so sorry, should be disregarded on the basis that he entered into it hurriedly with no legal advice and no legal advice and insufficient disclosure. He said he didn't understand it, and in any event, it didn't meet his needs. There's a detailed account of the way that this agreement came into being. And it's an interesting one because it is one in which the agreement was upheld, notwithstanding the fact that the husband had not received legal advice, and notwithstanding the fact that the agreement had been signed on the day of the wedding, albeit that some weeks had been taken up trying to negotiate the terms. The interesting part, which you'll find if you delve into the judgment, is that it really came out that the husband had understood the agreement, and one of the reasons for concluding that was that he himself had been making changes and amendments to the document, inserting clauses, and that was discovered that although he didn't accept that he'd made some of those changes, that they had been made on his computer, and that was the finding. And so that was the level of detail that the court and the parties delved into, was to ascertain the data in respect of these amendments and where they were. So the court found he did understand the agreement, and that it was pretty readily understandable. Financial disclosure was in broad terms accurate, although the husband could have made further inquiries about it. He didn't. And he had represented effectively that he was receiving legal advice, even though he didn't, and he'd had sufficient time to do it. However, all of that being said, as a matter of fairness, the judge did not find that the agreement should be upheld in its entirety. There had been a substantial change of circumstances within 2 years of the agreement. The wife had received 55 million from the sale of a family business, which previously, although the husband knew she was wealthy, that was tied up at the time. But also, importantly, the agreement didn't address the husband's needs, and this was plainly the biggest issue with the agreement. And in fact, the parties hadn't even considered his needs. The agreement had been based upon an agreement that was used by the wife's sister, and it had been adapted and amended, and there had been no thought really to what the husband would actually need in the event of a separation. And so unsurprisingly, it didn't meet those needs. And so an award was formulated for him, and along the lines of other such awards, it provided him with a housing fund that stayed with him only during his lifetime, but was held on trust for the wife, along with some other capital costs and some provision for capitalised maintenance. The court then moved on to costs. So finding that both parties' open offers missed the target, that wasn't an issue. As we get into these issues of costs as we go through, I think what you'll see is a number of cases where we're finding the courts really grappling with making cost orders against parties who should not have pursued particular issues in the litigation, and where those cost orders are invading a needs-based award, and that is the case here. So the husband was ordered to pay costs of 120,000 to be deducted from the lump sums, which we will have seen on the previous page, were calculated by way of his needs, and the court finding it proportionate to invade the need-based award on the basis that he cannot be insulated from the consequences of litigation, and that related to his case in terms of the validity of the agreement. Next case under our general principles heading is VV and VV. It's another case of Mr. Justice Peel. Short marriage, 5 months, very short marriage, no children. Such cases should be easy to resolve, apparently, but weren't in this case, at least for the parties. The issues were the extent of premarital cohabitation and the extent to which the sharing principle applied to the husband's assets, and then 2 competing strands of misconduct, which I'll come on to in some detail, as well as the wife's needs. And the offers were pitched some distance apart, the wife seeking a lump sum of 400,000. Sorry, the husband offering a lump sum of 400,000, and the wife seeking over 6 million, representing what she said was a half share of the husband's assets. So his assets stood about 11.8 million. So the issues were these: the husband, before the marriage, spent about a year working for a particular tech startup. He earned during that time some share options, which would come into being if he, as and when the company was listed. So it was the wife's case on marital cohabitation that year that the husband worked into the company and therefore accrued those share options were part of premarital cohabitation, and therefore she was entitled to share in the value of them. And the husband's contention was that wasn't the case. In respect of those shares, the husband pre-sold over half of his entitlement in the company for about 11.5 million. It was his view that there was about a 1 in 4 chance of these shares coming into a large value as opposed to being worth effectively nothing at all. So he sought to hedge himself. He didn't, however, tell the wife or tell the court. He did this during the ambit of the proceedings, and in fact denied that he'd done anything of the sort. He did that because he was concerned that the wife would tell the founder of the company and make it difficult for him to realise his shares when the company was listed. His conduct was described by the court as deplorable, understandably. The wife's conduct was slightly different, but related, and it was in fact what the husband feared. She was in contact with the company founder. She shared some confidential information with him from the proceedings, including a screenshot of the Form E, and he advised her that if she could prevent the husband from acquiring the units in the first place, it would be easier for her to negotiate a settlement. And during the proceedings, the wife accepted that she is being played by this person who had his own reasons to try and delay the grant of the shares to the husband, which is effectively to try and inflate the price, the share price, when the company floated. So the wife's solicitors then took the unusual step of asking the company not to release the shares to the husband pending the settlement, not copying in the husband's solicitors, although the company then wrote to the husband and informed him. And there became a bit of a battleground. The wife wouldn't consent to the shares being released. She threatened a freezing injunction, but didn't apply for one. And as a result, the shares were not released to the husband when the company was listed. And he very much missed the boat in realising how much they could have been worth, because the initial value of the company went very high and then came down within a matter of weeks. And the value that the husband put on that loss, because he did eventually get his shares, was about 76 million. but certainly in the tens of millions, the court accepted. So the court found that in relation to those two aspects of conduct, that the husband's conduct was litigation misconduct, which would ordinarily sound in costs, but the wife's conduct was gross and obvious, and she had recklessly interfered. She should have applied to the court and didn't, and her conduct ought to be taken into account. In respect of the cohabitation and engagement aspect of it, it's of some interest. Again, the law is set out very helpfully, and it concludes that ultimately it's a fact-specific inquiry. And just a reminder, really, because premarital cohabitation is almost always added on to the length of the marriage, and normally that's entirely appropriate. And it wouldn't make a significant difference. But of course, in this case, it was the difference between these share options being matrimonial property or not. They still had a significant value, just not as huge as it would have been. So the essential inquiry is whether the premarital relationship is of such a nature as to be treated as akin to marriage. And so one has to look at that and the parties' intentions and form a factual view about it. In that case, it certainly wasn't. And the wife had a needs-based award provided to her, rounded up to 750,000 in total. Again, looking at the costs of that situation, the husband sought a cost order of £450,000. The wife was ordered to pay much less. Of course, the husband's litigation conduct failed to be taken into account in terms of his non-disclosure. But again, we see the wife here failing to establish a case on cohabitation, failing to establish her sharing argument and her conduct issues. So it was again fair for her needs-based award to be invaded in order to pay out that cost order to the husband. And effectively, the court took the view, however she trims her needs to meet what she has to is a matter for her. Then move on to another decision of Mr. Justice Peel dealing with marital agreements. But just looking at the introductory comments first, this is the case that I made mention of earlier, in which Mr. Justice Peel commented that why should it be fair for one party to abide by the rules as to the length of their statement when the other party effectively rides roughshod through that and gets to put in more evidence and gain an unfair advantage. And that, I'm certain, will be something that you, as I have heard parties and clients complaining of, not infrequently, when they have complied with the page limit, but it's been ignored by the other side, and very lengthy statements have been put in. And what we have here is that complaint being taken seriously in the High Court, and that means that obviously we can take it seriously and press those complaints in the family court. This is the family court, but before the circuit bench or whatever bench we're appearing in front of, and try and ensure that there is parity, and where there isn't a parity, one can of course look for remedy in costs, or however else one might be able to put it. So that is the complaint. Moving on to the other helpful aspects, I should say, of this judgment. I've just set out there where you go to for the law on these various different issues that are considered in this judgment, all of which are ready to cut and paste into a skeleton argument, should you so wish. The premarital agreement here, I'll just deal with it very quickly. It's an interesting analysis because it's one in which the court found that the parties were in fact both under pressure when they signed the agreement. The pressure came from the husband's father. And not only that, but the wife felt stressed at the time, and that's something she told her solicitors as well. But the court found that pressure was not undue, and there was therefore no reason to set aside the agreement. The relevant creators here effectively says that there will often be a degree of pressure and stress and difficulty in negotiating and putting these agreements into place, but the test is to demonstrate that that pressure was undue, and that mere pressure won't cause the court not to uphold the agreement. So the same applied to the parties' post-marital agreement, which came sometime later. It did not raise the presumption that it should not be given effect to. And so, but what the problem that did arise was that the wife ultimately didn't sign that agreement. The terms had been agreed in correspondence, the court found, a clear agreement in correspondence, but the agreement itself provided that both party signatures were required before it could become binding. The wife didn't sign it. It therefore didn't raise the presumption that it should be given effect to unless it was unfair. But the court was entitled to take it into account because obviously the terms had been agreed, but it hadn't got to the stage of becoming a binding agreement. So that's how the court dealt with that particular issue, which is one that may well arise in other cases. There's then dealing with inheritance, prospective inheritance, so inheritance to be received well after, probably well after the parties' separation. In this case, the agreement had always provided that future inheritance should be excluded, but the court also looked at the foreseeability of the inheritance and didn't find that this was going to be something that was readily available at this stage. So no real surprises there in the application of that bit of established law. And I've just set out here the final awards, and the wife got 60%, going beyond the post-marital agreement in order to meet her needs. And just to note that the cost stood at about 13% of the assets as they were at that stage. So let's have a look at our next case. This is decision of His Honour Judge Hess. It's an interesting one, X and X from last year. No clean break, I've called it, because this was a case in which the court was not willing to determine the wife's capital claims. The husband was found quite late in the day, although suspicions were there, to have forged bank statements that he presented to the wife during the marriage. The circumstances were these, that the parties had been living in one country, and in 2014 the husband wanted to persuade the wife to move to England. She was reluctant, so he told her that he'd had an offer of 80 million for his company and showed her a bank statement showing a deposit of 8 million had been paid. During the proceedings, but very late in the proceedings, disclosure was received directly from the bank, and the bank statement revealed that it did not have those transactions. And so it became evident that the husband had manufactured that bank statement in 2014, or so the court found, and that the wife had held on to it. It was a paper copy and she'd had it all that time. In other aspects of the case, the husband had been extremely dilatory in terms of his disclosure. There had been 4 FTAs, I think, 2 ineffective FDRs before the final hearing was listed. And the issue the court was faced with was really this, that it's clear the husband had lied. It's not clear whether the 8 million had ever existed in another account. It's not clear if the offer to buy the company had ever existed. It was not clear if there were funds related to this whole deceit that he'd put forward, or not. But there wasn't the evidence at that hearing to make a Baker type inference that he had hidden assets. And the wife hadn't really had time to investigate because the bank statement had come, as I say, quite late in the proceedings. And so the court was just concerned that it didn't know what was going on with his disclosure, and there was severely lacking evidence in relation to other business interests. And so His Honour Judge Hess decided that the fair approach was to adjourn the wife's capital claims for 10 years. And he considers a number of different cases in relation to the adjournment or lack of clean break, and how to, when it's fair, not to have the finality of litigation. He thought 10 years was fair in this case to make those investigations, and he made a maintenance order in the meantime. So that's an option if you have completely unsatisfactory disclosure, but you're not in a position to say to the court, this is the inference that you should draw in terms of hidden assets, then this is an option that is available to protect clients' capital claims in those circumstances. So next case is another from the circuit bench, His Honour Judge Farker, in the case of Goodyear, and this relates to a provision that we've all become familiar with, I think, in the financial remedies omnibus order, the pension sharing order, and the provision that the parties agree that in event that the receiving spouse, so the person receiving the pension sharing credit, predeceases the other spouse after the order has taken effect but before its implementation, then the surviving spouse will have the consent of the personal representatives to apply to vary or set aside the order, to appeal out of time or set it aside. And so that gives the surviving spouse the first step in either of those processes, so the permission to make their application effectively out of time. So in this case, that came into being. The consent order was approved in January, pension sharing order to the wife, decree absolute in the July, and then very sadly the wife died in the August, prior to the pension share being implemented. And the application to set aside because of the Barder event came before His Honour Judge Farker. He considered a number of arguments. One was that that wording from the standard orders hadn't been used. He did not find that fatal, as the application effectively fell to be considered on its merits, which he did. And he found there were competing arguments as to how the pension effectively ought to be regarded. The wife, personal representatives arguing that she had a capital entitlement to the pension that had grown up over the course of the marriage, and so her death, on her death, it ought not to be treated than any other capital award, and the husband didn't seek to set aside any of the other capital elements of the award. And the husband, for his part, arguing that pension is income, and the wife evidently wouldn't be utilising that. And the court found that the thrust behind the pension share was to ensure the parties had sufficient income during their marriage. And if it had been known that the wife wasn't going to live more than 6 months after the order, the same pension share would not have been granted. And that was really found on the basis that although the PODE had been requested to and did provide figures for both equality of income and division of capital or equality of capital, each party in the negotiations focused in on the calculations that related to income, and that's where their negotiations centred. And there was not sufficient capital in the case that this pension could be regarded as being capital. They were both going to have to use it to fund their incomes, fund their retirement on an income basis. So the court having decided that indeed there was a barter event, looked at the rules and said, what do I do now? The rules say ordinarily one would send it back for a full rehearing if it's going to be set aside. However, if the court is satisfied it has sufficient information, it may proceed to determine the original application at the same time as setting aside the financial remedy order, and that's just what was done. There was no dispute about it, and the court set aside the 51% and substituted it for 25%, it being the judge's view that that reflected effectively the hybrid nature of the pension, and so that reflected the wife's capital or earned share of the pension, but provided a discount in respect of the income which she would not require. And the judgment just touches on the relevant intentions in terms of the barter event, which is interesting because the wife's intentions changed over time because she received her diagnosis, and at that stage she formed the intention that she wanted to leave her pension to those that she loved, but it was the intention at the time that the court focused on, and that was not the same. So that's a helpful illustration as to how this might work out if the provisions within the order come into effect, and how the court treated that. It's an illustration because it's a decision by a circuit judge and it's not authoritative. Very shortly touching on the case of Gallagher and Gallagher of Mr. Justice Mostyn, the facts of which I'm not going to go into. It relates to experts, impartiality of experts in particular. It was a case in which the parties had each had their own expert, not a single joint expert, and that expert evidence was in relation to a business. And it's fair to say that Mr. Justice Mostyn was not overly impressed with the husband's expert. He sets out in his judgment the words of Lord Justice Thorpe back in 1996 in the case of Vernon and Bosley, giving a warning really to experts as to how one must be mindful of the need to walk straight down the middle of the road and avoid the temptation to join the party who's instructing them. And sounding the warning as well that the difficulty in resisting that temptation is clearly severely tested if the expert sort of joins one party's team on the trial and effectively shares their attitudes and assumptions and goals. And that is an important note because in this case, the husband's expert had attended, I think, a 2-day private FTR throughout with the husband's team. The judge found that he had departed the middle of the road. He heard the evidence of the experts hot tubbed, so both in the witness box together, and you have there his view of that expert's approach in terms of how he approached the other expert. And he found indeed that expert had not been impartial. And it's quite clear, and it's important to note that, of course, experts, when they do depart the middle of the road, do nothing really apart from harm the party that they're trying to help, because that advocating instead of impartiality is not going to be accepted by the court, is quite readily discernible, and is only going to harm the instructing party in the end, as it did in this case. Another case of His Honour Judge Hess, in the short time that we've still got left. This relates to soft debts, and it's a case that I think has been well discussed in journals and online since it was published last year. But it's P&Q, and it deals with really how we approach this issue of whether a loan is hard or soft, and it's been well utilised, I think, already on the ground, because it provides a really helpful list of factors that we can focus in our thoughts on when we're trying to work out what we make of a particular obligation. So it kicks in at this stage. Once a contractually binding obligation is established, the court will go on to decide whether the obligation is hard and therefore gets noted in the schedule, or soft, in which case the court might decide to leave it out. And the factors that His Honour Judge Hess identified are not exhaustive, and they may fall to be found in different combinations, and it may not be entirely clear in every case which side of the line the debt falls. But the first quotation on this page sets out, I think, number of factors in favour of it being a hard obligation, including that there's the feel of a commercial arrangement or a written demand for payment. Could be something like a loan that comes with a charge on the property. It must have obviously a date for payment, things like that. The soft loans tend to be friends and family rising informally. Maybe the payment date has passed, or the amount of money is that is probably not going to be enforced. Again, it's a circuit judge decision. It's not seeking to establish new law, so it's not authoritative, but it is extremely helpful on the ground in terms of looking at the type of arrangements that clients have and how courts might be looking to treat them. The next case we're going to look at is a case of Mr. Justice Cohen. It relates to allegations of coercive and controlling behaviour, and how they sound out in a case of a postnuptial agreement. The wife set up an Edgar defence saying that she'd been subject to controlling behaviour, and that should be a vitiating factor. The court entirely accepted that if it was established, it would plainly be an example of undue pressure, and made the point that that Edgar was just as applicable now as it had been 40 years ago, and covered that range of conduct. But the court found that the husband's behaviour was not coercive or controlling, but the wife had pre-existing vulnerabilities in relation to which there was an expert report that she was not able to make a rational and considered decision as to what was in her best interest, and the agreement didn't meet her needs. And so the parties were some distance apart on their offers, but the wife was awarded an income fund, a very small capital fund, and a small pension share in order to meet her needs, but she had well overstated her case. On costs, again, which is probably a significantly interesting part of this case, very much determined on its facts. The wife's costs were huge. She was represented by leading and junior counsel at the hearing, and the court was critical. They were excessive and disproportionate. And again, she was criticised for the approach she had taken, and the conduct argument added nothing. She was already going to get home on the postnuptial agreement, on the basis of her pre-existing vulnerability, but of course it didn't meet her needs. And so the 2 days or so, plus other preparation costs spent on arguing the issues of domestic abuse were unnecessary. Her sharing claim was unarguable, and she got a needs-based award. The husband was criticised as well. He relied on the postnuptial agreement. That was completely unrealistic because it didn't meet her needs. So he was ordered to pay 80,000. That left her with an outstanding cost bill of 70 or 80,000, which was entirely of her own making, effectively. And again, that was money that she was going to have to find from her needs-based award for the conduct in the litigation. So start to get a real sense from these cases of real cost consequences following from these conduct arguments that are being pursued, and substantial numbers of them being in relation to attempts to vitiate the pre or post-nuptial agreements. So I'll just move on quickly to Adin and Adin. This is an extremely long judgment. It's His Honour Judge Wildblood. You get a sense from the outset of the type of proceedings these were. He says these are feral, unprincipled and unnecessarily expensive financial remedy proceedings. And there's substantial criticism in the judgment of the way that the wife's case was put. Effectively, she sought to establish that the husband had interest in a number of properties, and the procedure followed was, as I think we will all know, went completely off track. The husband issued his Form A, the wife issued separate trust proceedings in the county court, and it took an excessively long amount of time for those two to be brought back together for some reason. And in any event, the wife never really got her case together or put it properly. There was no evidence on which the court could find that the husband had any interest in the properties. And the judgment is excoriating in respect of her case, and it is quite plain that cross orders were going to follow from those findings. So not a great deal to take from this in terms of practice. I think we know how we properly deal with interveners' claims within the proceedings. They need to be formulated and put within the financial remedy proceedings, not by way of a separate claim, and directions will be given on pleading. And of course, one has to consider the evidence at every stage and discontinue, because the rules in relation to costs on those claims will be the CPR, and so cost consequences will follow from losing, whether or not that conduct was unreasonable. The last case I'm going to talk to you about is Gallagher and Gallagher, and it relates to reporting restrictions. You will probably have followed during the last year that Mr. Justice Mostyn had given a number of judgments. I think this is his third judgment substantively where he deals with this issue, setting out his views on publication, reporting restrictions and anonymity in cases which are not wholly about child maintenance, so your normal financial remedy cases. And it is his view that the general practice is wrong, and that the correct interpretation of the rules and the law must lead, he says, to the conclusion that the standard anonymisation of judgments is unlawful. So that's the standard publication of judgments with the rubric at the beginning, which says that the judgment has been anonymised, etc. What he says is that in order to put in place any reporting restrictions, such as not reporting names or anonymisation otherwise, you need to have a court order making that reporting restriction, making that anonymisation order, and in every case that can only be made where it has been applied for, and where it's been awarded after a full res balancing exercise. We need to be alive to this because this is a high court authority. It's extremely important. All judges are told that they should be publishing at least 10% of their judgments. The question is, are they going to be published anonymised? Are they going to be published with reporting restrictions? Well, if your judgment is going to be published on Bailey or on the National Archives, then you need to think about whether you need to make an application for anonymisation or to have reporting restrictions preventing children's names perhaps being reported. So it's a really interesting judgment. It's lengthy, it's detailed, it's very academic, and it bears reading. He Mr. Justice Mostyn also makes this point. He makes a number of points on a number of different issues, and that's why I say detailed sort of consideration of it is really beyond what I can achieve in the next few minutes. But one interesting point is this, that it is his view that if a party were to give counsel skeleton or even a financial document disclosed within the course of the proceedings to a journalist covering the case, that would not be a contempt of court. The more usual scenario, however, would be where a journalist asks the court to direct disclosure. One of the themes of the judgment is comparison as between the complaints and the submissions that are made in financial remedies proceedings about the disclosure of confidential financial information into the public domain as compared to what you might expect in a Talata case or something of that nature, inheritance acts perhaps, and finding that effectively are in no different position than parties in those cases are in civil proceedings. The reporting restrictions that he made were for the names, photographs, children, identification of where they live, not to be reported, as well as the content of some particular advice that related to the case. So I advise reading. I understand that the FARCA committee is going to be considering this point, and we can expect some guidance later, perhaps in the year. Alongside, I should say, just as another note for the diary, I think October 2023, we're expecting the updated Pensions Advisory Group report, PAG2, which will be obviously, I'm sure, just as much interest and assistance as the first one really was for us. The last point I'm going to talk about, because I'm aware I have about 3 minutes of your generous time left, is just to make a point and run through the provisions on the Domestic Abuse Act prohibition on cross-examination, which of course applies equally forcefully to financial remedy proceedings. Came into force 21st of July, so we're starting to see now cases which are going to trial, probably depending on which court centre you're in, certainly being listed for trial now. The relevant provisions are in the Matrimonial and Family Proceedings Act. The prohibitions are these: a person may not cross-examine if they've been convicted of or cautioned for a specified offence of domestic abuse, related domestic abuse, or they have an on-notice injunction against them. They must not cross-examine the alleged victim. They must not be cross-examined by the alleged victim. So those are the prohibitions. If those exist, then you move straight on to the next stage of what does the court do about it. If those aren't met, and in lots and lots of cases they won't be, and in financial remedy cases it's often the case that domestic abuse isn't flagged up to quite an extent as in children cases, because we're not dealing with it as conduct, because it won't meet the standard of being gross and obvious, and it won't be relevant to the determination, but it will still be there, and we still have to grapple with whether there should be special measures, participation document directions, and whether these provisions apply. So the court then has discretion if there are issues of domestic abuse otherwise, which relate to whether the quality of the evidence is likely to be diminished if there's in-person cross-examination, or whether there will be significant distress. And if those conditions are met, then with the court having regard to a list of factors, then the court has to consider if there's a satisfactory alternative for cross-examination. If not, the party must be invited, that's the cross-examining party, or the party who doesn't have a legal representative must be invited to arrange for someone to represent them to conduct the cross-examination. And if they don't, the court can appoint a qualified legal representative under the scheme, and there's a legal aid payment for that representation. And those are solicitors and barristers who are being required to do particular training, which includes the FLBA's advocacy and the vulnerable witness training. So that's the scheme. One has to be alive to it. One imagines We don't know how it's being applied as yet. Oh, apologies. I ended my slideshow. We don't know how it's being applied as yet, but I can be, I think, reasonably confident that, given the provisions in FPR 3A, that the courts are not going to be comfortable allowing in-person cross-examination in many cases, and so these provisions will be applied, and they will not take a huge amount of convincing that alleged victims of domestic violence are going to be disadvantaged if they don't have those provisions in place. Well, thank you very much for attending this webinar. I'm sorry that I won't have time to deal with questions, because I'm bound to finish by 6 p.m. so that everyone can go and have an evening. I just have time probably to tell you that our next webinar is going to be on the 16th of March. That's going to be Tina Cook-Casey and Catherine Archer. They are going to be talking about fact-finding hearings and asking the question, have finding of fact hearings as we know them disappeared? So I'm sure some of you will be there for that one, but otherwise have a good evening. Thank you very much.